Good evening, Father Dan, and good evening, dear classmates. So, tonight we will be discussing the continuation of law and morality, and the topics that we'll be tackling tonight will be secular and religious morality. So, before we get into these two terms that I mentioned and how we can distinguish them from one another, we must first delve into the definition of these two terms. So, uh, we start with secular morality. In secular morality, it refers to a system of moral principles and ethical judgments that are based on human reason, experience, and societal consensus, independent of religious beliefs or doctrines. Um, to to reiterate, it is defined as those ethical standards that are more based on reason, human experience, and societal values, completely independent from any religious influence or beliefs. Think of it like this: it's simply having rules for being a good person without any premise of religious belief, and those rules are more aligned with what's deemed as reason, perhaps common sense for other people, and the empathy to decide on what is right or wrong. And it's also mentioned here that this relies on philosophical traditions like utilitarianism or virtue ethics, which prioritize logical reasoning and the well-being of individuals and society without invoking any form of divine authority or sacred text. And if you can recall, utilitarianism, that's the benefit of the majority, or the greatest happiness of the greatest number becomes the determining factor of what is right or wrong without invoking any sort of divine authority. So now we move on um, to the second type of morality, which is religious morality. It is defined as being grounded in religious beliefs, sacred texts, and divine commandments, and it holds that moral laws are derived from a higher supernatural authority, such as God, and that ethical conduct is defined by adherence to these religious precepts. So, um, it helps guide and dictate what is right or wrong, providing a moral framework, but more grounded on the faith or the religious belief of that person. So it's quite similar to what we previously discussed on the, if you can recall, the hierarchy of law, specifically with eternal law and divine law, where it is said that laws derive from a supreme being or a higher supernatural authority, where in this case, instead of where laws come from, it's more on where morals or ethical conduct is defined by our adherence to these religious precepts or our faith. So it is provided in the 1987 Constitution in Article 2, Section 6, that the separation of church and the state shall be inviolable, and we we know that this is the provision that institutes the separation of the church and the state, and this is some sort of an application of religious influence in our very laws and the system of governance. Um, well, not really an application, it's more on setting the boundaries of religious influence and integrating it to the state. We have certain provisions that provides for the roles of the church and and their significance in our system of governance, and such as this one, Article 2, Section 6, which ensures the separation of the church and the state. And later on, we will discuss another provision that signifies the role of religious belief or the religious institution in our country. Well, and this isn't really this isn't exactly new, because the separation between the church and the state have been going on way back in the colonial times. And this, as you can see here in this slide, these are the instances where the separation of the church and the state were instituted, and such as this one, the Malolos Constitution, the Treaty of Paris, President McKinley's instruction to the Philippine Commission during the American colonization, the Philippine Bill of 1902, the Autonomy Act of August 29, 1916, and the 1987 Constitution of the Philippines, which we adhere today. Um, Given our extensive experience during the 333-year colonization period of the Spaniards, and during the time, if you can recall our history lessons, the priests or the frailes used to be these powerful, influential individuals back then. So there wasn't really a separation of the church and the state because uh, they they kind of served like a as powerful as the political figures that we have today. Like they manipulate the system as much as they can. So after the 1897 revolution of our Filipino revolutionaries, they established the Malolos Constitution, which we can see right here, and it followed up until the present 1987 Constitution. So, what does Article 2, Section 6 mean? Uh, Here, it entails the legislative intent provided by the framers of our Constitution that the state or the Philippine government must maintain a clear and strict division between religious institution and the government function. And there are certain parameters of what this division kind of set, but that will be discussed later on. It is it is also said that the state cannot enact laws which will aid or give preferential treatment on one religion over another, nor can any person be punished for his religious beliefs. And through this provision, it ensures that our government remains neutral. They remain the neutrality uh, provided regarding religion, preventing any religious institution from becoming state supported or being favored or been or given favoritism. A concept that we should actually take note of is that this provision in the Constitution actually ensures what we call religious freedom, as you can see here in the last part of the slide. So, what is religious? What is religious freedom? It is the liberty of every individual possesses to worship or not a supreme being, and this is actually guaranteed in our own constitution by allowing individuals to practice their religion without any interference from the state or discrimination of any kind. And through this, we now have a right to a more pluralistic society, diverse in many forms of beliefs that can coexist peacefully. So here are some limitations on religious freedom. Uh, Number one, if said religious belief clashes with established institutions of society and law, the former, which is the religious belief, must yield, and it must give way to the latter, which is society and law. And the second one, if the government steps in and either restrains the said exercise or the religious exercise, or even prosecutes the one exercising it. So we're not gonna tackle on a landmark case wherein this particular limitation provided for religious freedom was exercised by the Supreme Court in the landmark case of Estrada versus Escritor, where it involves a setup on a marriage issued by a particular religious institution that were in contrast with our own laws. So this is the landmark case of Estrada versus Escritor. And here are the facts of the case. Soledad Escritor, while still married to another, she cohabited since 1980 to one Luciano Quilapio Jr., who was himself married to another woman. And both of them had a 19-year-old son during their marriage. The private complainant, Alejandro Estrada, he was not personally related to Escritor, nor was not personally related to Escritor, nor did he personally know her. But however, he wanted the court to declare Escritor as immoral the relationship of escritor with filiapio in consonance with the pertinent provision of the administrative code, because given because this is because escritor is actually an employee at the time, and since she contracted a bigamous marriage, regardless of her religious belief, Estrada believed that she could be liable for the provisions of the for a with the pertinent provision of the administrative code. So in the defense of Escritor, she contended that under the rules of the Jehovah's Witnesses, a religious sector of which she is a member, the act of signing a declaration pledging faithfulness is sufficient to legitimize a union which would otherwise be classified as adulterous and bigamous. So now she alleged that in compliance with the foregoing rules, she and her partner they signed what you call a declaration pledging faithfulness. This is actually just provided under her religious institution, which is the Jehovah's Witness. Take note, it's called the Declaration Pledging Faithfulness in 1991. And by virtue of such act, they are, for all purposes, they are regarded as husband and wife by the religious denomination of which they are devout adherents. So now the issue at hand is whether or not uh, Executor's right to religious freedom should be carved out as an exception from the prevailing jurisprudence on illicit relations for which government employees are held liable. Because, uh, of course, the contracting the bigamous marriage, if you can recall, in the defense of Escritor, she contended that they procured a what you call this a declaration pledging faithfulness in 1991, and for all purposes, she and the other guy should be regarded as husband and wife. So now we go to the ruling of the case. So the court ruled that Escritor was not administratively liable, and by invoking the religious beliefs, practices, and the moral standards of Escritor's congregation, in asserting that her conjugal arrangement does not constitute disgraceful and immoral conduct for which she should be held administratively liable, the court had to determine the contours of religious freedom under Article 3, Section 5 of the Constitution. This is another provision in the Constitution guaranteeing religious freedom. First, it was the separation of the church and the state. Now we have the contours of religious freedom under Article 3, Section 5 of the Constitution. And the application of this was the basis of the Supreme Court by not holding escritor administratively liable. And this is where the court took cognizance of the matter to explain the aspects and the concepts that one should know when it comes to the application of religious freedom in cases like this. So we go now to that specific article, so we can further um, understand the ruling of the Supreme Court. So it is provided there that no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. The free exercise and enjoyment of religious profession and worship, without discrimination or preference, shall forever be allowed. No religious test shall be required for the exercise of civil or political rights. And in this provision, you can notice in what we highlighted in the provision, there are two clauses in which comprises the constitutional framework that protects religious freedom, and this is defined as the free exercise clause and the establishment clause. So in the free exercise clause, it is you can find it in the clause that mentions prohibiting the free exercise thereof. So in this clause, it prohibits government from inhibiting religious beliefs with penalties for religious beliefs and practices. So in this clause, Filipinos are granted by this constitutional provision the right and freedom to practice their religion freely, including worship, observance, and religious activities, and the government will be required to not interfere or discriminate the entities and the individuals based on their religious beliefs. So now we go on to the second clause, which is the establishment clause, and we can find it in the clause that mentions the establishment of religion. So no law shall be made respecting an establishment of religion. So in this clause, it says it prohibits the government from inhibiting religious beliefs with rewards for religious beliefs and practices. Some examples for this are like prohibiting the government uh, religious from creating religious institutions, or maybe endorsing an official state religion, so that the government will maintain neutrality on religious matters and ensure that there will be equal treatment of all the religious beliefs and the non-beliefs. Because of course we it would be unfair if the government would establish an official state religion. This would discriminate the other religions that were established here in the Philippines, like our Muslim brothers, and our the Protestants, Jehovah's Witnesses, and so on. So now both of these clauses, they aim to promote freedom of individual religious beliefs and practices, and both were intended to deny the government the power to use either the carrot or the stick to influence individual religious beliefs and practices. Now, in interpreting religious freedom, states and governments in other countries have their type of jurisprudence that guides the interpretation of the concept of religious freedom. And these jurisprudential views, uh, are classified into three principal theories, as discussed in the ruling of the landmark case of Estrada versus Escritor. And one of the jurisprudential views becomes the basis of the ruling of the previous case that we discussed. And perhaps not just in this case, but it is integrated in the framework of our constitution, particularly with religious freedom in the Philippines. So now we go on to those classification of views. Um, this is actually derived from the jurisprudence of the United States, and according to that particular jurisprudence, they identified three strains of jurisprudence on the religious clauses. Uh, Number one, we got strict separation theory, or the no aid theory. And then the second one, we have the governmental neutrality theory. And the third one, we have the benevolent neutrality or accommodation. So we go to the first view. So this view is anchored on the Jeffersonian premise that a wall of separation must exist between the state and the church. But why should there be a wall of separation? Who who protects one from who? So in the strict separation theory, the wall of separation exists to protect the state from the church. So there's kind of what you call hostility, the hostility of the state towards the influence of the church, or the influence that the church may bring to the state. And by only a complete separation of religious institutions, providing for a free choice among political views without any religious influence, necess- necessitating that strict wall. So you can see here in the graphic on the right side. So uh, the state's hostility towards religion, uh, it allows no interaction between the two. So it guarantees that the the church will not linger any form of influence towards the state that may influence the political views of its constituents. So that's the strict separation theory, or the no aid theory. The key goal of this view actually is to protect the state from the influence of the church. Just to reiterate, and we go on to the second theory. Now we go to the government neutrality theory or the strict neutrality view. It's kind of similar to the previous view that yes, there's still a wall of separation, but just because there's a wall of separation, it does not require the state to be their adversary or their enemy. So the hostility part is removed. So, and instead of being hostile to the church, the state must be neutral in its relations with groups of religious believers and non-believers. Coined from the term itself, government neutrality. So, in the government neutrality theory, some examples uh, on where it was applied. It is actually encapsulated in the First Amendment in the United States and a case on Everson versus Board of Elections. So, um, just to reiterate, the government is not allowed to be hostile. It doesn't just remove the hostility, but it does not allow the government to be hostile or play favorites with religious institutions. So this actually ensures the neutrality, the neutrality state on where the government has to adhere to. Okay, although on the application of this view, particularly with interpreting the Establishment Clause, it could lead to a de facto voiding of religious expression in the free exercise clause because similarly with strict separation view, as mentioned earlier, the government would still avoid any involvement with religion due to its impartiality or neutrality. This is where the wall of separation is being used because although there is no hostility, since the state remains neutral, it does not involve itself in the affairs of religion, and this may include symbolic or accommodative gestures that the state should should give to its constituents on exercising their religious beliefs. And since the state is impartial, they cannot provide uh, what I mentioned earlier. Even the acknowledgement of religious holidays may be prevented or even disallowing prayers in public events. Regardless if the government shows no hostility on the practice of religion, the strict neutrality avoids any involvement to defer favoritism. So you could say that the free exercise clause it will instead be moot as reasonable accommodations that we enjoy today on religious practice may be restricted since the government will be barred from any action relating to religion. So we can conclude that the government neutrality theory is completely incompatible with the free exercise clause. Now we move on to the last theory. We have the benevolent neutrality theory or the accommodation view. So this recognizes that religion plays an important role in the public life of the United States, uh, wherein the government recognizes the role of religion and how it plays an important role in the public life of the state. So, unlike the previous views that I mentioned earlier, which is the strict separation and the strict neutrality, which demands that the state establish that wall of separation to avoid any interaction, interference, or involvement with the religion, this last view, or the benevolent neutrality view, we see religion with benevolence as coined from its term. So in benevolence there is tolerance and most of all accommodation. The government becomes obligated to accommodate religious practice whenever possible, even if it means adjusting otherwise neutral laws that substantially burden religious exercise. So you can see here that it is shown in many traditional government practices in in particular with the United States. We have in God we trust. Is you if if you have a US dollar right now, you could see the phrase in God we trust. And the second one nation, one God. And then in some in most cases of the Supreme Court of the United States, there's a clause there that says God save the United States and this honorable court. And Also paying a chaplain to lead representatives in prayer. And hold on. So, in respect with governmental actions, accommodation of religion is allowed not to promote the government's favored form of religion, but to allow individuals and groups to exercise their religion without hindrance. So, it should be understood as a view that it is, that does not promote the state's favored form of religion, because the goal of benevolent neutrality theory is to simply remove the burdensome effect on the religious exercise. Does not it does not aim to promote the state's favored form of religion. So if we can recall, the strict separation view aims to protect the state from the church, as I mentioned earlier, right? That's the goal of strict separation, to protect the state from the church. That's why there's a wall of separation. And the strict neutrality view, it aims to remain impartial in dealing with religious matters. So there's no involvement or there's no interference, but there's no hostility as well, and compared to strict separation view. But in benevolent neutrality theory, it simply removes the burdensome effect on religious exercise of these laws. So the free exercise clause of the um, the free exercise clause is now being applied here, where our laws in the Philippines adhere to, balancing religious freedom with the state's neutral stance towards religion. And now we understand that this is actually the view in which the Estrada versus Escritor is applied, and this becomes the basis for the rulings on matters with religious freedom, as well as of uns- the framework of the Philippine Constitution. So the benevolent neutrality or accommodation view becomes the spirit, intent, and the framework underlying the Philippine Constitution. And this view effectively, or this theory rather, it effectively reconciles the concept the concept of religious freedom with the state's commitment to neutrality towards religion. And we can even observe it in our daily lives, such as the imposition of tax exemptions on religious activities, the observance of legal holidays associated with uh, with any particular religion, public schools offering religious instructions. If you can remember, during your elementary days, we'd have catechism lectures, if you're familiar. And we also observe that there are instances where our government or our public officials, they participate in religious activities while acting in their official capacity to serve their citizens, such as attending interfaith dialogues, community events, rehabilitation of religion structures as part of cultural preservation efforts, and so much more. So now we go back to the ruling of Estrada versus Escritor. So by not holding Escritor administratively liable for merely adhering to her religious practice as a Jehovah's Witness, the court applied the benevolent neutrality theory in interpreting the free exercise clause in Article 3, Section 5. And such theory requires the government to accommodate religious beliefs unless there is a compelling interest. So here's a message from one of the known political leaders of the United States that I want to share with you, that entails what we've discussed today, particularly with the religious freedom. So it is not an accident that freedom of religion is one of the central freedoms in our Bill of Rights. It is the first freedom of the human soul, the right to speak the words that God places in our mouths, by George W. Bush. I would now like to call to the floor the reporters of the next topic, which will cover obscenity and pornography. We have Miss Daniel Iturralde and Miss Rachel June Lopez. So, thank you so much.
Good evening, everyone. This is Baby Daniel Aturalde. Good evening to you, to Attorney Dan. I'm going to talk about the law and morality about obscenity and pornography. So, first, the word obscene and the term obscenity may be defined as the meaning of something offensive to chastity, decency, or delicacy. So, in simple terms, when the law used the word obscene, it's talking about material like books, images, or films, or simply as something visual. Um, for example, let's say a cartoon, a video, um, a cinema, something that used for entertainment, or something that are conceptualized into the media arena that is seen as morally repulsive or shockingly indecent because of its explicit focus on sexual matters. So this part, pornography comes in. So obscenity and pornography um, are intertwined with each other. So what does it mean when we say it is offensive to chastity, decency, or delicacy? So first, offensive to chastity. This refers to things that attack or corrupt sexual purity or virtue. It's about material that encourages unchaste rather, or inappropriate sexual thoughts or behavior. Like, for example, pornography or those lewd designs or lewd videos that we could see in some tapes, cassettes, or even in the social media. Second, offensive to decency. This is about violating the general accepted standards or principles of society or proper public behavior or manners. In this context, it means the material is so sexually explicit or graphic that it goes beyond what society considers acceptable or decent to share publicly. So, what are these things? Um, when we, when it comes into our mind, what are these things that it's so explicit that it offends the norms or societal standards? Same as those things that are very outrageous or sexually outrageous that are deemed very inappropriate or very obvious that is offensive to our values and norms. And lastly, offensive to delicacy. This refers to offending a sense of what is refined, what is modest or sensitive. The material is considered crude or in bad taste, particularly concerning sexual topics. Um, as reiterated again, it's those pornographic materials, those lewd designs, and those that are very blatant and explicitly inappropriate um, for such audience. Essentially, the law defines obscenity as material that is so sexually shocking, as what I've said, and repulsive that it violates the core moral and societal standards of the community regarding sex and public propriety. This legal concept is crucial because in many jurisdictions, obscene is a material is not protected by freedom of speech, guarantees allowing the government to regulate or prohibit its distribution. To further expound, as stated in the Book of Aquino, a common law crime which is somewhat akin to the offense now before us is called threats. And here it has been held that the indictment need not set out the exact words of the threat, it being sufficient that the substance be stated with certainty. Again, so as to the offense of obscenity, it has been held that an indictment for using obscene language need not set forth the language used. Indeed, for the information to reproduce a letter in haec verba would be equivalent to publishing it, would be to permit of the very thing which the law is trying to avoid. The exposure to public gaze of matter essentially private in nature. The purpose of the law would should be effectuated, not frustrated. So, it simply states that in the indictment of a case regarding obscenity and indecency, such as threats or um, or the like, it is not um, it's not it is not essential. It is not compulsory that um, it should be verbatim. That the words written in the indictment of the case per se would be a haec verba of the lewd or the obscene words itself, because it would be tantamount to republishing the obscene words. The text states that for crimes like threats and obscenity, the law values certainty of substance over word for word reproduction in court documents, especially for obscenity, because reproducing, as I've said, the offensive material would defeat the purpose of the anti obscenity law itself. For writing it verbatim would spread or scatter the obscene words or the offensive words that we prevent for the people to be um, to be known for it, or we prevent for the people to have knowledge in it. Avoiding public publication. If the court had to reproduce the obscene language word for word or in haec verba, the court document itself would essentially be publishing the obscenity and exposing it to the public. Furthermore, the law is trying to prevent the public exposure of indecent matter. Allowing the charging document to reproduce it would frustrate or defeat the very purpose of the law. Let us remind ourselves that the law's goals should be achieved and not undermined. On the other hand, indecency is an act against good behavior or delicacy. The test of ordinarily followed by the courts in determining whether a particular publication or other thing is obscene within the meaning of the statutes is whether the tendency of the matter charged as obscene is to deprave or corrupt those whose minds are open to such immoral influence, and into whose hands a publication or other article charged as being obscene may fall. So let us give emphasis on this one, that the first obscenity test is is whether the tendency of the matter charged as obscene is to deprave or corrupt those whose minds are open to such immoral influences, and into whose hands has a publication. Other article as charged being obscene may fall. Another one, the another test of obscenity is that which shocks the ordinary and common sense of men as an, an indecency, rather. Next, the Philippine statute does not attempt to define obscene or indecent pictures, writings, papers, or books, but the words obscene or indecent are themselves descriptive. They are words in common use, and every person of average intelligence understands their meaning. Indeed, beyond the evidence furnished by the pictures themselves, there is but little scope for proof bearing on the issue of obscenity or indecency. Whether a picture is obscene or indecent must depend upon the circumstances of the case. So our Philippine statutes, or Philippine laws, doesn't really provide a strict rule to define what is obscene and what is indecent. Um, it really depends on the circumstances of the case. To further add about that, um, the law doesn't give a strict definition of obscenity, as reiterated. Instead, it relies on how ordinary people understand the word. Courts often use common sense and community standards to decide what counts as obscene. One dictionary meaning is offensive to decency or chastity, especially things that show nudity or immoral acts. As um, as reiterated again, such lewd designs, lewd videos, pornography, and um, those graphic contents. Judges may expand this definition based on the material that affects people's minds, which expands this definition based on how the material affects people's minds. The key test is, or the key question for the test of obscenity is that does the material corrupt or influence people, especially the young, vulnerable, in a bad way? So picture a child, an innocent child. Um, the simplest determining factor whether a material is obscene or indecent is whether when I give this material to this kid or to this person, does it corrupt their minds? Does it influence this kid in a very bad way? So that's the basic question to be reflected or to be pondered upon in ascertaining whether this material is obscene or graphic. Furthermore, if something causes impure or indecent thoughts, it may be legally considered obscene. In the case of Judge Thayer in U.S. versus Clark, Judge Thayer observed that the society uses certain standards to judge what is decent or pure, especially in books and education. These standards are meant to protect public morality and guide young minds towards virtue. Excuse me. Literature and education play a powerful role in shaping how people think and behave. If public materials like books or lessons promote indecent or immoral ideas, they can negatively influence society. That's why it is important for writers, educators, and publishers to uphold moral values in what they produce and share. So, tests of obscenity. Courts use a standard test to decide if something is legally obscene. To say it again, the key question is, does the material have a tendency to corrupt and morally damage people, especially those easily influenced? If a book, article, or image might lead someone, especially young or vulnerable people, to think or act in immoral ways, it could be considered obscene. Another way to test obscenity is, does it shock the common sense or decency of ordinary people? So, courts use a standard test to decide if something is legally obscene. In short, if something is likely to harm people's morals or offend basic standards of decency, the law may treat it as obscene. Further elaborate, indecency and is an act against good behavior and just delicacy. So it's somewhat intertwined, or I mean, it is intertwined with obscenity. They work hand in hand. So in the case of People versus Gopin, the court said if the artwork are displayed for artistic appreciation, not for commercial profit, they are not automatically offensive. Because there are arts um, that are for um, freedom freedom of speech. It's also an art. It's also there's also an art that portrays a naked body, those graphic things, but its purpose is not to offend the society, rather to reflect or ponder upon the lessons inculcated in that artwork. So it is purely artistic appreciation. The intention behind the exhibit matters. If it's meant to promote art if it's let me restate it. If it's meant to promote art and culture, it's more acceptable. However, if the goal is to make money by attracting people with shocking or indecent content, the artistic value might be questioned. Such that, let's go to the core example that we have: pornography, nude videos for profit. The court also noted that some people might attend out of curiosity, even if they find the images disturbing, but that alone doesn't make the exhibit illegal. So it doesn't mean um, the way you perceive the material or the art exhibit, it doesn't mean because we have a different kind of explanation, or we have different perception of every art. So it doesn't mean that that's your explanation about the material doesn't make automatically that doesn't make the material automatically illegal. So it always boils down to the purpose of the exhibit. In short, art isn't considered obscene just because nudity it shows nudity or controversial themes. What matters most is the purpose, context, and the audience of your art. So that's my part of the report, and I would like to give the floor to Ms. Lopez. Thank you.
GR number 80806, dated on October 5, 1989, with the petitioner Leo Pita doing business under the name and style of Pinoy Playboy versus the Court of Appeals, Ramon Bagatsing and Narciso Cabrera. So, facts of the case. On December 1 and 3, 1983, pursuing an anti-smut campaign initiated by the mayor of the city of Manila, Ramon V. Bagatsing, and together with the Special Anti-Narcotics Group, Auxiliary Services Bureau, Western Police District (INP) of the Metropolitan Police Force of Manila, seized and confiscated from dealers, distributors, newsstand owners, and peddlers along Manila sidewalks the magazines, publications, and other reading materials believed to be obscene, pornographic, and indecent, and later burned the seized materials in the public in the presence of Mayor Bhagat Singh and several officers and members of various group organizations. Among the publications seized and later burned was Pinoy Playboy, the magazine published and co-edited by the plaintiff Leo Pira. So December 7, 1983, plaintiff filed a case for injunction with prayer for issuance of the writ of preliminary injunction against the respondents, Mayor Gatsing and Narciso Cabrera as superintendent of Western Police District of Manila, seeking to enjoin or restrain said defendants and their agents from confiscating plaintiffs' magazines or from otherwise preventing the sale or circulation thereof, claiming that the magazine is decent, artistic, and educational magazines, which is not per se obscene, and that the publication is protected by the constitutional guarantees of freedom of speech and of the press. In his answer, the defendant, Mayor Bhagat Singh, admitted that the confiscation and burning of obscene reading materials were voluntarily surrendered by the vendors to the police authorities, and that the plaintiff's establishment was not raided at all because this confiscation was also undertaken in the pursuant of the presidential decree number 960, or which was amended article 201 of the revised penal code. So the issues of the case. One, whether or not the defendants and their agents can, without a court order, confiscate or seize plaintiff's magazine before any judicial finding is made on whether the magazine is obscene or not. Second, whether the publication Pinoy Playboy magazine alleged seized, confiscated, and or burned by the defendants are obscene per se or not. So the rulings of the case, RTC first ruled and it denies the motion for a writ of preliminary injunction, dismissing the case for lack of merit. It was also later affirmed by the CEO Court of Appeals and explained that although um, the alleged obscene publication or materials deserves close scrutiny, however, the state has the right to protect society from pornographic literature that is offensive to the public morals. And in regards about the searches and unreasonable searches and seizures, it recognizes certain exemptions, and one of it is the consent given to the search or seizures. And that was also claimed by Mayor Bagat Singh that this magazines publications that were seized and burned was voluntarily given by the peddlers or by the publication itself. However, the Supreme Court reversed the decision and the decision. So the reason why Supreme Court ruled in favor of the petitioner, that is because the court is not convinced that the private respondents have not or have shown the required proof to justify a ban and to warrant confiscation of the literature because they were not possessed of a lawful court order. Because these court order um, is actually or it justifies that the said materials that were seized or that will be seized are pornographic, and also these it also presents authorizing them to carry out a search and seizure by a way of a search warrant. That is why in order or before the state could do search and warrant, the state must demonstrate first the existence of a danger of that certain materials. First, it must be clear, but also in order for them to justify the action for search and warrant. And if there is a proof that that said material is obscene and somehow indecent, that's a time that these people that should be held accountable is still um, or still or it should they should still be guaranteed of the due process. So when does a publication have a corrupting tendency, or when can it be said to be offensive to human sensibilities? Also, when can we say that that kind of material is obscene or not? Determining something as obscene or indecent, it is somehow vague or it is an a broad concept. That is why the court laid down the test in determining the existence of obscenity, and these are as follows. First, whether the tendency of matter charged as obscene is to deprave or corrupt those whose minds are open to such immoral influences and into whose hands a publication or other article charged as being obscene may fall. Two, shocks the ordinary and common sense of men as indecency. So this explains that whether a picture is obscene or not or indecent must depend upon the circumstances of the case, and that ultimately the question is to be decided by the judgment of the aggregate sense of the community reached by it. So that would be all. Thank you.